What is a construction dispute?
A construction dispute is when there's a disagreement between parties to a construction project.
What are the root causes of construction disputes and where the Building Control Act addresses them?
If I'm building a road, for example, and I do an excavation, and then someone comes and crashes into that excavation and dies. Before the act, there is nowhere you would hold whoever dug that accountable.
One of the major causes of a dispute is when the expectations are not met.
One of the other issues that can cause a dispute is a design.
We get back to architect Martin.
Exactly.
His design. If I'm putting up a structure on my farm, do I still need an approved plan?
Yes. Yes.
I would say yes.
And a drawing from him?
Yes.
You may not necessarily get a drawing.
Can I afford the cost?
Before a man is to build, he is prudent enough to understand whether he can actually meet the cost in order that he doesn't start and fail midway.
What is the purpose of this act? You're all welcome to our third podcast of arising out of our collaboration between the Construction Law Institute and the Uganda Society of Architects. With me are distinguished professionals or practitioners in the built industry, celebrated in the market, I would say. I leave that for you to judge out of the podcast. But a little bit about the Construction Law Institute. Construction Law Institute is a get-together, I'll put it that way, of different professionals. We have lawyers, we have architects, quantity surveyors, engineers. We don't have engineers. So they are all professionals. There are no courts and court people who are not professionals. Most of us are all registered in our different professionals. And of course, the partnership with the architects does bring the umbrella of the built industry. So we have these series are dubbed as design, decisions, and disputes. So we have 3 Ds to deal with in this podcast. Our topic today is why projects fail. What are the root causes of construction disputes and where the Building Control Act addresses them? But before we dive into the subject for today, I would want to introduce our distinguished panelists. We have all taken positions. I'll start with myself. I'm Kenneth Akampurira, an advocate, a fellow of the Construction Law Institute, a member of the Chartered Institute of Arbitrators of the UK, Uganda chapter, and the Honorary Secretary of the chapter in Uganda. On my extreme left is one of us whom we've dubbed as the old man on the podcast. Looks young, but is the old man for us here. Not old, but old. None other than a quantity surveyor who's celebrated with over 20 years of practice, Mr. Philip Kaheru. He's a fellow of the Chartered Institute of Arbitrators. I'm still a member, so he's a fellow. He's also a fellow of the Construction Law Institute. And Mr. Kaheru has more than 20 years. I'll correct myself, 30 years of practice. Across small, medium, and large-scale construction projects in Uganda, he's the Director and Senior Project Quantity Surveyor at Earthrail Associates Limited. Too much English, but it's okay. Delivering full life cycle consultancy from feasibility through final handover, and he has overseen small, medium, and large projects. He's a director and fellow at the Construction Institute, I think I said that. A fellow at the Chartered Institute of Arbitrators, I said that. He's also a Royal Institution of Chartered Surveyors, FRICS, a fellow, correct? And the Institution of Surveyors of Uganda. He's the chairman, Board of Trustees of the International Cost Management Standard, ICMS Coalition, a trustee member representing the Institution of Surveyors of Uganda, and Dispute Resolution Foundation Board. Dispute Resolution Board Foundation, DRBF, right? If I got any of your small acronyms wrong, I apologize. I got them right. Okay, super. I'll pat myself on the chest and say I got them right. Okay. Second to my left is Engineer Solomon Ndugwa Balemezi. I won't interpret that in our local lingua, but engineer is a civil and structural engineer with over 20 years of experience spanning across multiple disciplines in the construction of infrastructure projects in Uganda and the built environment. He's held roles in the consultancy industry, government agencies, multinational companies, and is currently working on the Tilenga project, Uganda's flagship oil and gas project. So please, he's close to Hoima than any of us in terms of commuting. Okay, so immediate to my left is architect, not architecture. Okay, architect. I think architecture is the
Course.
Is the course.
Subject.
So we are past the course. Okay, so now architect Martin Isaac Bongomin. He is the director of Design 256 Limited, established in 2015, and he has been in practice for over a decade. He holds a bachelor's in architecture from Makerere University and a Master of Science in Building and Urban Design in Development from the University College of London. Correct?
Correct.
Okay. He is the current Vice President of the Uganda Society of Architects. So I won't ask him to tell us what about architects are, because we do not have any secondary school kids who are being inspired on that. But we'll run quickly to our next aspect of this podcast, and I think that's where many of us are looking out for. Philip, your farthest to me on the left, and your QS, the Quantity Surveyor. Just briefly lay the foundation, given the topic that we are dealing with today. What is a construction dispute and when does it arise? And we'll apply the Jaja test. So you'll explain to your grandmother. The presumption is there are lawyers like me who are watching us on the podcast and they would love to understand what is a construction dispute and what does it, and when does it arise?
Thank you, Kenneth. Thank you for this opportunity to come and share knowledge. As simply put, a construction dispute is when there's a disagreement between parties to a construction project. It's important to note that parties are those that have signed a contract. Those could be employers, contractors, normally. So it is basically when there is a non-fulfillment or a breach of a contractual right or an obligation by any of the parties to that project, that contract, that brings these disputes. So when we have, for example, if you are to pay a contractor for work that he has done, according to the drawings which architect Martin has approved, the designs which engineer Solomon has certified, I have valued, then there should be payment. It is the contractor's right to receive that money. But there will be a breach or a non-fulfillment arising out of that if the client or the employer, the financier, does not actually make that payment at all or on time. So that is where the obligation of the client is. His obligation was to pay the contractor for the work that he has executed. And it is the right of the contractor to receive the money for the work that he has done. So simply put, it's a disagreement between two contractual parties.
Thank you very much, Philip. It's a disagreement between two contracting parties. Contracting parties look at the employer, the contractor,
Yes.
and subcontractors, I think, to a certain extent. Okay, definitely, I think one of the disputes that do arise do touch with the work done by architects.
Yes, that is correct.
I think we start with you, right? Wrong design.
Yes.
Not on your projects.
Not on my projects.
Yeah, no.
Definitely not on my projects.
God forbid, not on your projects. But
So,
what would be the causes? And I get to you, Martin, as the architect on this
Yeah,
podcast. What would be
thank
the
you.
causes of such disputes? What would cause a dispute?
thank you, Kenneth. I'm glad we're having this podcast. I'll dive straight into one of the major causes of a dispute is the fact that there's a reality. You know, as architects, we are the pioneers, or not the pioneers, but I would say, let me use the right term, correct me. As the architect, we are the authors of a project. Now, normally what happens is the client has a dream and an expectation. And normally, one of the major causes of a dispute is when the expectations are not met. In other words, what is the reality versus what has been presented differ. And it can come up as a factor of very many issues. Could be from the client side. Let's say client expects a particular impression, it doesn't come out. Could be from the contractor's side. In the BOQ, he's expected to carry out a certain task. He doesn't meet the task. Could be on the cost side. Could also be on the engineer's side. So normally, this is where you find realities are not met. Maybe I can pass it on to Engineer Solomon to add on to part of his experience.
In terms of cause of disputes.
In terms of cause of disputes, yes.
Yeah. Thank you so much. One of the other issues that can cause a dispute is a design.
We get back to architect
Exactly.
Martin.
Exactly.
His design.
And I can cite an example. For example, you notice these days clients like so much designing apartment buildings, but because of the limitations of space, they want the lowermost floor to be a parking, and then you start all the usable spaces above. Now, when the building is, because you have to just put columns and you have to leave spaces for the vehicles to pass and park. But now such a design is very prone to, when an earthquake comes, yeah, because the building is not well braced, it can easily collapse. You get it? And now that can cause a dispute between the client who contracted the engineer to design, or if the engineer decides to go all the way and make sure that your building is as earthquake resistant as possible based on the design that an architect has provided or the requirement by the client, probably it becomes a very expensive design, and probably the client has no money to build it. Or you've seen many buildings, especially people who like building uphill. Then you find that for you to make such a space workable, some areas have to be excavated, and I'm talking about very deep excavations. Now, when you do those excavations, then you have to retain the walls. So you can find a significant part of the budget is spent in building retaining walls.
Preparing the site.
Just preparing the site. To a client, because Philip may have given, you know, when the client is starting, the QSs have those preliminary cost estimators using the area, using the type of building that it is going to be. And then they come up with an initial estimate.
Okay. Engineer Solomon, you've taken us through site mainly, but there are aspects of variations. I think those would go to my dear old man on the podcast, Philip.
Yes, Ken.
One of the causes for disputes is variations. which also, of course, would swing this side to architect Martin. Maybe just throw some more light on variations and how they impact on disputes arising out of the variations. And I want to take it up from where he left it in terms of designs are made available to engineer Solomon, and then we have the structure supposed to be going up, but our client, as usual, the employer, thinks that we should now have an excavated basement, extended pergolas for sheds, then something on the rooftop, like maybe there's a party house, maybe there's a small turf field there also to play football for the dwellers in the apartment. So just touch on that in terms of disputes arising out of the variations.
Thank you, Kenneth, and I thank Solomon for his and Martin for their contributions. So variations really basically an indication of what is from what was. There was a concept, a perception of what a project should be, and then there's the perception of what it is in terms of what the client wants. What Architect Martin will tell you and appreciate is that, as he said, they bring the vision of the client to life, but sometimes the interpretation of that vision gets distorted between what they expect and what they find. Hence the additional scope of work at the time of execution, the additional excavations, the turf you talked about. So that is where now variations come into play. And it also then goes in as far as the contractor, because when he comes in, he has a mindset that he's only going to do a certain set of work in a certain period of time, and that's it. Then now you're telling him, no, you need to add this, you need to add that, you need to add this, which he hadn't yet comprehended. So these changes in scope bring about disputes, disagreements, because sometimes one party might feel that may not necessarily warrant an additional cost, whereas another one does, or even additional time. So there is that discrepancy, that disagreement, which may arise and then escalate when there is a non-meeting of minds, if I may, yes.
Thank you. I now want to advance a bit in terms of we've now laid the foundation of the disputes as they arise, and what's a dispute, when will they arise, what would be the causes, the unique kind of disputes that arise in terms of extension or enlargement of time, payments, and then variations. Those are typical disputes that would arise in any construction. But I want to draw a small analogy from the infrastructure constructions, that's dams, layways, and roads, and public buildings like our parliament or even the Serena Hotel. I want to bring it down now to the apartments I was talking about, and we domesticate it to that level, that now we are living infrastructure which is governed by standard form contracts like the FIDIC and the others operating within the region like the NEC and all the others. We now bring it down to the apartments that we live in, the homes that we build, because now there's some liquidity, I think, for professionals. So we build now serious homes, in my view,
that is correct.
In certain places, maybe apart from me. And now we're looking at how professionals can be assimilated into complying with all these causes that could arise. And why we get to that is because we have now a new creature in the built industry, which is the Building Control Amendment Act of 2026, which was assented to on the 19th of March 2026. So this year we have a new regulation. And I would want maybe Engineer Solomon to just lay foundation, since you are part of this compilation of the statue that we're now dancing with in the built industry. Just a brief background of how this actually comes into play in the built industry. And we'll be looking at what is the purpose of this act? Because we could have an animal in the built industry and we're not aware about it. It's
Very
about
good.
to eat us alive, especially
Very
as
good.
professionals.
Yes.
But first question, are lawyers also affected by this act? Said I put disclaimers.
Well,
But anyway, first make a submission and then I'll take it up from there.
thank you so much, Ken. Maybe to lay a foundation, I'll need to take you back a few years ago when there was no Building Control Act. But buildings were going on, people were building, and one of the challenges we had at the time, I think there was the only place we would find something related to buildings was in the Public Health, I think Public Health Act,
Yes, Public Health Act.
where there was a little bit of building, and rightly so, because a building discharges sewage, it has air quality. So that element of public health, now that was the only place you would find anything related to building.
Dwelling houses.
Now, if there was an accident, there's no person who would take liability. If there was a delay in maybe approving your designs, there's nowhere you would hold anyone accountable. I remember a time when I worked on a design for a client, and the approval took 2 years. And in those 2 years, the drawings would get lost, and then you'd be required to make a resubmission. It was actually up to you to make a follow-up. You get it? When secondly, there was nowhere to get redress if you've submitted a design and then it is rejected and you're not given a reason. There was nowhere, no one you'd
You'd
report
walk
to.
away.
So in a way, the local authorities had kind of become small gods in this. So you'd be at the mercy of the person who was seated behind the desk. And all these, so many challenges. So the professionals sat together and then came up with the Building Control Act, the first one of, I think was 2013.
2013. Yeah, 2013.
It was created, you get it. But then they realized, okay, the act is there. How do you operationalize it? We don't have standards. We don't have regulations. Then wait a minute, we still have a long way to go. Now, to operationalize the act, there was need to create the National Building Review Board. There was need to create the building regulations. There was need to create the National Building Code.
Yes.
There was need to create the scale of fees, and because even when you'd come to fees to pay, each jurisdiction had its own quantity, amount of money. You'd not know in Kira they are charging a different amount. In Kampala City they are charging a different amount. So there was no unified way of coming up with a standard way of charging or billing. Hence the regulations. That was done. Now that I think the regulations were completed in 2019, now you could operationalize the act. When the act was operationalized, of course, like any new thing, even your house when you build, you realize there are some small defects. There was need to amend because there are many things in there. You get it. And then
When you talk about many things in there, in terms of, you're talking about the operationalizing of the 2013 Act.
yes,
Those are the many things in there.
yeah, some.
Can you
were
just
not-
give us maybe 3 or 4 things that were in there that needed an amendment? Because we need now to look at the 2026
For example,
and see
I'm
what
going
it brought on
to
board.
I'm going to bring it in terms of the amendment.
Yes.
One of them was the membership of the board. you realize that the people at the local authorities are under local government. But the whole industry of building is under Ministry of Works. Now, when you'd, for example, go and maybe there's something you needed to the building control officer to attend to because the National Building Review Board, which was responsible for operationalizing the act, is under Ministry of Works. It had no authority to instruct a building control officer to do something. I mean, they don't report to them, they report to the Ministry of Local Government. Now, one of the issues that has been addressed is the Minister of Local Government, I think now sits on the board, together with the Ministry of Works, together with Lands, Ministry of Lands. Because you realize that the built environment cuts across different ministries. Planning, that is lands, local government deals with the people who are responsible for approving your plans, and then Ministry of Works, which now deals with the actual boots on ground. So it was very difficult not to operationalize. Now the amendment sorted that out. It brought all those guys together on the same table. You get it. So if there's any problem in the local government, the Minister of Local Government or someone from the local government is on the board.
I've read the two acts,
Yes.
2013, 2026. I realized that one of the old act was more or less silent
Yeah.
and maybe more comfortable for professionals like Ak Martin
Yeah.
to go and do whatever he wants to do, and he goes there with a small penalty of maybe $1 million. Then also, I myself, the employer or the owner of the building, I could also alter my designs and do whatever I want to do, even walk away from his designs, isn't it?
That is true.
And I would leave. Has the amendment done anything to us who want to be very creative in terms of designs? Without
think
going
so.
back to the architect,
I think so,
I
but
can tell
think,
my guy to amend the structure now. Let's have bigger rooms as opposed to what is on. Maybe Martin, you could.
Yeah, I could
address
expound
that.
on that. You see, practicing with the previous laws, we did not. We were actually we had a lot of room. We would contravene certain things that are in the new act, of course. Of course, I said this slightly, contravene. It's not we intended to.
No.
But
You turn a blind eye.
We turn a blind eye, exactly. Thank you. That's the legal term for it. But what I would say is that we never used to have all professionals on board, definitely, with the previous act. You know, most times you'd find that the architect is working on his own without any advice from the engineer, from the registered engineer. And you'd find that because they would try to cut on costs, because it became an issue of cost management, actually. So you'd find that in my firm, I would hire a graduate engineer, a graduate QS. I wouldn't seek the advice of a registered person. And normally, this would tend to fail the project because someone who is not registered, first of all, doesn't hold the legal ground to cover you in terms of project execution. For example, if a building collapses, you don't know who to hold liable. You can't hold an engineer liable. If there is a cost overrun, you can't hold a graduate liable, but you can hold a registered engineer and a registered QS liable for all those issues. And now the good thing is that this new act has actually forced us to work together as professionals. That is one thing I can say, because in recent times, we've seen the advantages actually of the act. Some of the advantages of the act, that's one of them.
So the previous practice of you stamp my plans and I move on does not work anymore?
It doesn't work anymore because actually I would tell you, even from my site, I get visits from inspectors and they call to find out. And also it has woken up the registrars of the different professionals because they have to go and find out who is the professional in this job, and the clients can't run from this. That's a beauty. The clients can't run from this because they actually have to have a person on record to hold responsible, given that the penalties now are very steep.
Yes.
Yeah?
And I had to touch the aspect of penalties, and that's why I was saying that can I still go away with my 1 million shillings for a variation in the drawings or for building without an approved plan?
Kenneth,
Yes.
no.
Even my small house.
No. You see, the Act provides...
No. Let's be very clear on this one.
Yes.
If I'm putting up a structure on my farm or a piece of land that I've inherited, let's say deep down in Gayaza, away from the main road, away from the likes of the big estates that are coming up, do I still need a building, an approved plan?
Yes.
I would say yes.
And a drawing from him?
Yes.
You may not necessarily get a drawing.
Can I afford the cost? The house?
That's another discussion.
I will say this about the cost. The good book tells us before a man is to build, he is prudent enough to understand whether he can actually meet the cost in order that he doesn't start and fail midway. So, before you build anything, let us first understand, can we actually complete this project? So, it is prudent on any person building, entity building, to first understand, do we have enough resources to do this project? Resources doesn't necessarily only mean money. It means professionals in the built environment, possibly even lawyers for the, for understanding what they're going into. So it is important that, yes, we have all this in place. And like you said, you might be down there, but it might be that you get visitors from Kampala, high level, because you are, secretary,
High level
CIA,
person.
SIAB.
Thank you
And
for
then
the-
somewhere there,
for the amplification.
yes, somewhere there, your building starts having issues, and then there are problems, God forbid. But at that stage, however remote it is, it becomes a concern. And the Act provides for penalties for not having permits for building, without permits. One, not getting permits, but also building ahead without permits. Previously, it was a simple fine, but now it has been tagged to even the area of building that you're constructing. So the bigger the projects, the more the cost in terms of fines.
Engineer Solomon, what are the fines? Because we need to be very clear on the fines. If it's 1 million, I can live with it. Because the cost of a foundation is
Because
not a million.
there is also imprisonment.
Actually, there's been a recent run for people to get occupation permits. I think there's one time when KCCI announced that, people who are living in structures without occupation permits,
We're going to condemn your
we are
structure.
going to condemn your structure. Now there's been everyone has been running around.
Actually,
But give me the comparison 2013 and 2026, sir. I can be very very clear on whether
I'm going to
actually
give you that
to be-
one.
Yeah.
But before I give you that comparison, I want you to look at it in terms of safety. When I was in the NBRB, I remember one of the cases where we worked on a mud and water structure in the village collapsed and killed 3 children. Mud and water.
Mad and Wato.
Yes, it was raining. There's another one, a more recent one, when a musical artist organized the festival and the stage collapsed. You get it? Now, the fine is not about because maybe they hate you, but it is to promote safety. So they've made it a little bit deterrent for you to do the wrong thing, because people have lost lives. Now, the person who has died or the person who has gotten injured in that mud and water, some temporary structure, which you say, I don't need an engineer, will not think the same going forward. So it's about safety.
So the act more or less was put in place to address concerns of safety.
Safety.
Number one,
exactly.
collapsing buildings. I think
exactly.
I think it must have been in engineered by the many collapsing buildings that we're having in Kampala, especially the malls, isn't it?
Okay.
Downtown and along, I think even around Bukoto. But now you're also bringing the aspect of platforms
Yes,
for musicians.
exactly.
Do they need also permits to put up a platform?
Yes, they do. Because if you go into the Act, they define a building and a building operation.
Yes.
If I'm building a road, for example, and I do an excavation in the road, and I don't warn anyone, and then someone comes and crashes into that excavation and dies, before the Act, there is nowhere you would hold whoever dug that accountable. But even now, because an excavation can be defined as a building operation, now you can take someone accountable for having done something like that, or without putting proper signage.
I want to get back to the platforms. I have a concert. I want to set up a platform in Nambole or any open stadium.
Yes.
Do I need a permit for that?
Yes, you do. And
To build a platform
It's got under
for
the
Thursday.
temporary structures.
So Thursday, if I have an event happening on a Thursday and there is Monday, I must go to the local authority and get.
And you get a permit for
That's
putting up a
interesting.
structure. You've not heard of the was it a circus? Was it something somewhere in Kalere?
Okay.
Which collapsed and killed some,
Yes,
I think,
it
primary,
did.
were they primary pupils or pupils in nursery?
The
That
last one
merry-go-round.
The last one I remember was a cave. I don't know if you remember a cave where they brought.
Yes.
That's long ago.
So exactly. Now,
that also requires.
that is something that is supposed to be handled by
Temporary.
professionals. Because the people in the lay people do not know. Someone has just put up something very nice, you go.
Hold on again.
And then you lose your life on that thing.
Engineer Solomon.
Yes.
I'm now getting a little bit nervous. So, do I need an architect? Do I need an architect?
Definitely, for
Yes,
sure
you
you
do.
do.
So, Martin must come
Yes.
and supervise my
Actually,
platform.
Definitely. You see, Kenneth, we have a problem in Uganda. Very many people think that you just go and get your local carpenter, local steel welder, and put something together. But everything has a weight. This of course to do with structures. Everything has a weight. Everything has a breaking point. Everything has, a limit. Now, of course, when you look at things like platforms, you're talking about, let's say, a stage for an event. There are things to consider as an architect. For example, security, circulation. How are clients coming in, moving out? Where do the security stage? Where do you park your cars?
I think we will not allow you to
I will not continue there.
continue there.
But
The other aspect is
Yes,
it is a
yes.
standard structure.
Yes. Okay. Now
Let's be honest.
The point we're
It's a standard
talking.
structure. It
Yes.
comes well designed, ready.
Okay. Now you see there.
So do I need a permit for that also? To put it
you
up?
see, yes, you do.
Education, okay. You'll appreciate, and I think we all appreciate. We've all gone to secondary school, primary school. We went from P1, P2, P3, P4, P5. For us to be eligible to proceed, to progress, there had to be exams. You needed to be tested. The word tested. To be seen to be fit for purpose for the next stage. So those tests made sure that, yes, you are right. You can represent, This is the same thing that the Building Act is doing. In order for us to have safe buildings, in order for us to reduce on accidents, we need to have safe structures. And in order to have safe structures, some of the building codes and standards need to be met. And the people to ensure that those standards are met are the professionals who have studied and know what is permissible and what is not. Just like lawyers would go to court to argue a case, because you're permitted, you have studied to do so. I cannot necessarily boast and say I would do the same because I may not have gone to law school to do it. I needed to have studied a certain way. So in the same way, engineers have the knowledge and skill, architects have the knowledge and skill, and to do these various things that make sure the buildings are safe.
Okay, can I just add something? It's very short.
Yeah.
In my time mastering, I used to go to a lot of these events abroad. And what happened is before, I mean, you look at let's give a good example, like the company Apple. I think everyone in Uganda almost knows what an iPhone looks like, or the latest that's coming, and there's a lot of hype about it.
A certain age, yes.
Now, the thing is, if you look at organizations like Apple, they have architects, they have engineers. You look at any large company now, making concerts in European countries or whatever people call Bulaya, you, before putting up something, of course, you must get authority approval, and the person to see or curate that, the curator is either an architect or an engineer. Those jobs are actually there. They advertise for curators who have knowledge in architecture or engineering to put these together. In Uganda, I don't know. I have to check, but that has given us something also to look into. We've done several projects in the years of practice up country, several, in lodges, in national parks, remote places, where no one would know these places, these structures exist. The building conditions in every part of Uganda vary. Karamoja, different. Western Uganda, different. Southwestern Uganda, Kisoro, different. Kampala, different. Eastern Uganda, different. Eastern Uganda, we have landslides, you know that very well. Northern Uganda, we have a lot of rocks, very rocky, sandy platform. Western side, you have very soft, very green area, soft soil. I think that's how we have very nice milk coming from there and soft meat. But you see, there are different areas, and also there was a study, I think, being done under Ministry of Energy, different energy zones. And also we are looking at different building techniques for the different parts of Uganda. Imagine this is within our regions.
Yes.
That is why I happen to be part of a select committee handling that. But to bring you to the issue of capacity, I think there's a lack of capacity. I don't know. I'm not in government.
Not an enforcement.
I'm not an enforcement officer, but I think there's a lack of capacity. Why do I say this? Is because people need to be trained in various regions to have the knowledge to ascertain whether the building is right. That is one. Because
what designs work in this place?
Yes, from my experience designing in these different places, you find people are not knowledgeable. And you'll find maybe an environmental officer supervising your building, and you have to educate him. Thank God that a professional is hired. You have to educate him on what should happen. So this, I think, the law is very good. The implementation, I think that's a discussion for later, is another thing to look at. Yeah.
Okay. From the reading of the two acts, again, you look at the spirit of the act is more of a deterrent. So the penalties are really hefty. We move away from the fixed fine of 1 million shillings to square meter now, isn't it? What is your comment on the spirit of the act? Is it meant to stop real estate from thriving? Because it seems to be out of the roof. You're getting more to project size, isn't it? If the penalty is project size, so some structures will never go up, in my view. Just 1 minute for you to comment.
I really...
Let me speak, because it's directly on cost.
Okay, fine. Yes, cost.
Yes, there's cost.
Yes.
But there's also an element of law, but...
Yes, just like I said earlier, when you start a project, it's important for you to understand whether or not you have enough resources. If you have comprehended that aspect, you would not get into this situation. So whether it is the 2013 or 2026 amendment, it doesn't touch you, because you have diligently gone through the process of ensuring that your project is successfully completed. And that is what I want to encourage us with today, that before we do these building projects, let us conclusively deal with all aspects of the project, ensuring that all avenues are met.
So the deterrent penalties are meant to get us compliant.
Yes.
To have standards, to have safety in place, and to avoid what used to happen, I think, in the past. Fine. I think we are now on the same page. I think I understand you very well. I'm getting home. My only place where I need to be addressed, I mean, to be brought up to speed in the built environment, and this act is the aspect of if I have a dispute as a contractor, as the employer, against my architect for giving me drawings that don't work. I have a QS who's giving me numbers that don't speak. Then I have the engineer, Solomon, who has done wrong calculations on the steel, and one side of the building is tilting, and is telling me that's the design. Yeah? So how do I get recourse? Because in my view, standard form contracts are very clear on how we handle disputes. We either meet and talk, you are allowed to compensate me. We fail, we go for adjudication. We fail on the adjudication. I don't agree, you don't agree with the award that has given me, that I've been told that you're supposed to pay me $1 billion. You continue to arbitration. Then you have an award. In this Building Control Act, I don't see remedies for us who are giving you the work.
Yeah. So
is that something to address?
Maybe I can go fast because I have the top of my mind.
Could be having something.
Yes,
in that line.
I have actually quite a lot to say, but I'm going to try
in 1 minute
reduce
because
it.
I think
I'm going to try and reduce it. So these are the things to look at: contract, client, professionals, and project. The Building Control Act addresses enforcement. It doesn't necessarily address dispute resolution, okay? That's what at least I've checked and found. It doesn't, and also what I realized from looking at it, there's no board, like from recent cases that I've seen and experienced, there is no board which actually addresses disputes amongst the consultant, client, contractor, for example. So, and the other weakness I've seen in Uganda, I know you're a counsel, but I have to be open with you. In my decade of experience, I have found very few legal minds that can interpret and understand construction law. Thank God there's an institute now that is taking that up, because of these are very big monies that have to be dealt with. We have a big challenge because many legals don't understand. I've been in some cases whereby I had to be consulted about and had to explain to them about the different stages of construction.
I think understanding is an overkill. Let's say appreciate.
Appreciate. Yeah. Actually, I think the word I'm looking for, correct me, is appreciate.
Yes.
Because there's so many technical aspects. Now, the law, I want to bring it back to the subject, the law and the contract resolution, there is a big gap. And it doesn't address, it addresses enforcement, but doesn't address disputes. And I think right now, if you look at Uganda, most disputes are resolved by the courts actually. And also it leaves, because the contracts are not, and why is this so, is because the contracts are out of the professionals' hands. Yet before, we used to have what they call an East African contract. But now, I think it's obsolete. And many clients don't trust the East African contract because they believe it gives professionals too much power. So that's where the problem is. It's about maybe the power, I think, to control the project, because people go away disappointed. One of the three parties goes away disappointed. So it's an issue of power, of controlling the contract, and someone feeling safe, back to safety. But this is now safety of my money, safety of me as a professional, safety of the contractor. It doesn't address so many issues. Delayed payments, wrong build. It doesn't address like delayed payments, issues which are contractual. Risk allocation doesn't. So, and also you find the problem we have is because of the lack of appreciation of the construction law, many clients also don't appreciate construction law, and therefore when the contracts are being drafted, they only look at what benefits them, which is, I want to use my money and I want you to pay back in case this fails. That's what they look at mainly.
Yes.
This is the money I'm allocating, and in case it fails, you have to be liable. That's what clients look at. They don't look at many other aspects.
Could it be also an aspect of cost of getting a professional?
Yes.
So we get back to you, of course,
Yes.
cost again.
Yes, Kenneth. I think in my experience, I've seen that certain clients have carried out projects where, for example, there are no quantity surveyors beyond the initial cost estimate. But during construction, the only supervisors are probably foremen, and probably not even the registered architect who designed, because he feels that the allocation of professionals on the job is money wasted, or money that can be put into additional space or something like that. And then it only hits them when, for example, I have known and seen where you find a beam running through the middle of a window opening. At that stage, there's not much else you can do because there's a misinterpretation of drawings. But whose fault is it? You see, so as Architect Martin said, there needs to be an appreciation of the professions in the execution of these projects, and therefore our inclusion from the start up to the end. It is not money wasted. I think there's the aspect of prevention of the so-called penalties.
The money is in buying the materials. In the professions, I would want to have a negative.
Prevention is better than cure.
Cure, yes. Now, I think the message today is that I think our main takeaway is the prevention is better than the cure. I think the cure is in the dispute resolution, isn't it? So more professionals on board handling the project, less disputes. But if you have a dispute, you're still left in the cold because the Act does not address that. So which means we are left with our ordinary court-going disputes. I think what would be our message to those who will be watching our podcast tomorrow?
I think the message is, number one, always. I think I have different messages for different the different players in construction.
So compartmentalize us. And
yes, I want to compartmentalize everybody.
Our prescription.
First of all, I think let's start with the client. With the client, always seek the right professional and ensure that they're registered, and also ensure you have all professionals you're working with. That is one. And also make sure you have the right legal interpretation of construction and its laws. Second, I would say to the professionals, now with this new act, before I think people used to get away with a lot of things, but let's make sure when we come to do a job, do it wholeheartedly. I think that should be the biggest take for us professionals. And also the other most important thing is to don't work in isolation. Right. For me, I think that's the biggest one for all professionals. Everyone on the team has a role to play, and you can't be a jack of all trades. To the contractors, I think, contractors, I would just say, please have more professionals that you work with. Have your own professional team, because this also affects the project in one way or the other. You can cause a client loss or a client to win. And then to the legal community, I would really say that I would pray with CLI in position. I would pray that we have more lawyers who appreciate construction law. It also goes all the way to the top as well, even judges and all. We need more people to appreciate construction law, and it's a beast on its own. Thank you.
Thank you, Martin. I think I'll give you some comfort on the legal side. Our Law Development Center now has a course that students must do during their commercial law week. They must do something on construction and procurement, because it's a new child or a new kid on the block for our legal practice. So we're trying to harness to ensure that at least we build capacity on the legal side. So be rest assured, something is being done big time. Anything, engineer?
Yeah, my take is I'm glad that there's a Construction Law Institute So the Construction Law Institute should take more interest in construction projects, especially the big ones, because there's a lot that you learn right from the contracts. Because I mean, the contract is the one which is for construction. You'll find that it's mainly, most of those are drafted by professional engineers, quantity surveyors, architects, and I doubt the lawyers kind of have acquainted themselves with some of those contracts that have been for a long time that have been being used to run these projects. I think the latest one is FIDIC, but each of those has it's been brought to address particular problems, and whenever they've done an amendment in those contracts, it's because there was a problem and some fingers were burnt, and then you get it. So just like my colleague Martin has said, the lawyer should take keen interest.
Please hold your guns.
Appreciate is the word we are going. Appreciate is the word we are going with.
I appreciate the industry.
Yes. Okay, fine.
That's what I can.
We do appreciate your concern for the need for us to enhance our skills to add on construction law. And some of us have actually gone ahead of the curve and have decided to do our master's degrees in construction law strictly.
That is
where you venture into arbitration and adjudication, and you say, arbitration I've heard about, what is adjudication? And you expect to find engineers only. And QS is like
QS says just to add on that. QS, I remember when we were in school, one of the things they used to caution us is to try so hard not to go the legal way. Whenever there was a dispute, we should try so hard to solve it as professionals, because once it goes on the other side,
the whole game runs out of
the judgment. we would not find it making a lot of sense.
So the ball leaves the pitch.
One of those.
Since it's World Cup, so leave the pitch and the gallery.
one of those such decisions, and I'm glad my colleague Martin is here. Is the Mera investment thing with the architects.
That's another podcast. That's another podcast.
That's another podcast. But I wanted the old man of the clan to go last, because he has those 30 years.
Yes, you always serve the best.
But I wanted just to add on to what he said. I think we need to change our mindsets.
Exactly.
Because the way the construction industry is going, all the clients I've seen today are smarter. People are getting smarter and clued up on what architects and professionals should do, what an architect is, and whoever. And some clients, sometimes, and that's why I mentioned earlier on about character, can get into a project knowing that they're going to rip you off. This is something, maybe another podcast you need to have, coming into a project knowing, you know what, I'm going to get all my fees back. I need to find something to make this architect lose, something to make this contractor lose. It goes
that's right.
back here. So I think we need to change our mindset, even as professionals, that we shouldn't fear the law. We should actually also appreciate and know where we are right, where we are wrong, how to manage our clients. It's very important. Yes, thank you.
It's a good podcast, I think, that we'll have on that one, because it will be now unpacking the construction contract, isn't it?
That's right.
For professionals to understand.
Yes,
so finally, lawyers will have a day.
Indeed.
QS, Philip?
Yes, thank you, Kenneth.
Yeah.
Architect Martin, engineer. My take is that we really need, one, to embrace the amendment. I think it's a welcome change. It only makes the industry more robust, and we give the public a safer industry. We give the public safer buildings, safer structures. I think it also goes to the professionals for us to be in the project. There will be no more excuses for, should I say, non-professionalism. We need to come in and do diligent work. That is why we are signed up for this. It's part of our ethical conduct that we do things for the good of the project and for the good of the public as well. So we would want to give our best to this. And I think in terms of the clients, let them get educated in this construction industry and what's happening. It's not enough for you to simply say, because I have my money, I will build. I think they also need to be invested in it. We as professionals may take the lead in educating them about some of these things. Rather than leave them blind, let us have them included in the process as we move along, so that they don't say that we did not know. So once you're included in it all, it's very difficult for you to have a dispute arising. But in case there is going to be a dispute, let us have contracts that include clauses for dispute resolution. And that wherever amicable settlement agreement is not reached, then there is an avenue within the ambits of the contract to resolve these disputes, rather than simply escalating them to litigation and court.
Thank you very much, QS Philip.
Yes.
As we come to the end of our podcast, it is clear that the Building Control Act might not have a solution for me as the employer, but it gives me one take home, that every time I employ a professional, they will definitely demand for a contract. So I believe we'll be addressing the aspects of dispute resolution, extension of time, quality of work that has to be delivered by each player in the contract, and also aspects of design. I don't think I'll do any work with him without a contract. Neither will I have you on site without a contract. Neither will I have the QS without a contract. So whilst the Building Act might not provide for dispute resolution, the nitty-gritties of what happens at site, our disputes that do arise out of the construction itself, but the emphasis of professionals being on deck on site, I think brings into the contractual regime. And that will give us another podcast, I think, in my view, to delve into the contract now, isn't it? Thank you very much. I think we do thank the leadership at the Architects Society. We also thank the Construction Law Institute. We embrace the MOU. We look forward to more MOUs with the respective players in the built industry. I think the QSs on Friday had their gig. We are about now to sign an MOU with them, since now they have an association. So they are now identified. So I think we'll have previously all under the engineers.
Yes.
Take no offense. At least there's an umbrella somewhere where we can now go, I think, have some synergies.
That's right.
What the Act now does is bring you guys together. Our MOUs will bring the lawyers on board through the Construction Law Institute.
Sure.
Thank you very much
You're welcome.
for turning up on time, sharp, prepared with your brains sharp. Thank you.
Thank you.